I knew it'd only be a matter of time before a tribunal ruled against the Department of Work and Pensions, and evidence like closing claims in the bank statement saga. In one hand, I have a whole load of letters from DWP that my subscribers have sent me, and in the other hand, I have a printout of an Upper Tribunal judge that has stated that DWP's own defence against a universal credit claimant was utter nonsense. That same Upper Tribunal found that the Secretary of State have used incorrect terms in their own defence in the entire appeal, where they closed a universal credit claim down because they said a universal credit claimant had not submitted evidence to them when they said they should do so. And that same Upper Tribunal have said that even when DWP themselves try and state regulations from the Universal Credit Act, the Social Security Act, and even the Personal Independence Payment Act, that they still get it wrong, failing to actually use those regulations lawfully in their own defence against a universal credit claimant. Well, if you've been one of those people that have been told that your universal credit claim is going to be closed down because you haven't submitted evidence, then this video is joyfully just for you. Now, as we can see here in the Upper Tribunal, there has been a universal credit claimant that has actually taken or appealed DWP's decision to close their claim. Now, we're going to be going through this claim bit by bit and the outcome that the Upper Tribunal have made, which is completely against DWP. And whilst you may think that that is completely shocking, if you've ever been in a court process with DWP and you know how utterly sloppy they are and how they really do not know the law at all, least of all their own guidelines, well, it's going to become to no shock at all to you that the Upper Tribunal have ruled in the favour of this universal credit claimant. Now, from this ruling that has now been made, this is now going to set a precedence for lots of other people to come. But most of you don't know about it, which is why I'm sharing this with you. Now, whilst this is clearly not legal advice, it's going to give you a case to refer to. If you're in this situation where you have lawyers, you can ask them to use this case. And if you're in the Justice Journal's membership, you're going to be getting a whole load of resources this month which are going to relate to this. So if your claim has been suspended, if your claim has been closed down, then the Justice Journals has got your back. Just know that. Okay, so basically what happened in this claim was this. DWP closed a universal credit claimant's claim because that universal credit claimant failed to give them evidence. Now, I have been saying in my entire playlist, which you can find here, for a very long time, that actually these sorts of things can't be done unless there have been a very serious change of circumstances and a few other things as well. And I know that because one of the things I did used to have to do was investigate claims that were closed down and do a lot of the prep work before claims were being closed down. Now, the key takeaway here, and in particular in this claim, is that the Upper Tribunal stated, which is the case even now, is that once universal credit is awarded, it becomes a final legal decision then from that time. Now, in this case, What DWP did was that they tried to make the case stick from the time somebody had claimed their universal credit. Now, once the decision of entitlement is given, so once someone has been awarded universal credit in law, that is a legal decision, as the judge has stated in the Upper Tribunal. And that decision cannot be undone just because somebody has not provided evidence. Now, if DWP, for example, want to change that decision, if they want to change the entitlement, they have to go through a legal process to do so. And that was clearly not done in this case here. And I have to say, some of the things that the judge has stated about DWP, I mean, he does not take any prisoners. That's all I'm going to say there. So let's get to that bit first, because we all need a little bit of motivation, don't we, when we see wrongdoing. So let's start with this one here. As will become apparent, but is worth emphasising at this stage as a matter of law, suspending the claim in the context of the facts of this case and then closing the claim are both legal nonsense. And he goes on to say that the recital, and recital means literally that this is a term the judge has used to say this is obviously something that they have just recited. It's something they spew off to everybody. And lots of you have put this in my comments on YouTube as well. So it's clearly a blanket email that goes round to everybody. It says the Secretary of State's appeal response to the FTT proceeded to be set out in Section 5, which is called the decision maker's response. If you've been on universal credit, we all know about the decision makers. This recited terms of Regulation 45, which is very important here, of the universal credit, personal independence payment, job seekers allowance, and employment and support allowance decisions, and regulations of 2013, regulations 37 and 38, which I've put this in my data pack, guys, all of this. We go through all of this. He says here, so he says that this recital, they have just left hanging in mid-air. And he then goes on to say that by this, I mean there was no attempt by DWP to explain in the appeal response the relevance of any of those decisions under appeal. I mean, damning's not even the word. This is what I say to you guys. Guidance is not law, but even the law, they're not even stating and following the right laws here. Shocking. Now, if you read this claim, and I'm going to link it down below so you can, it clearly says there that he had a message saying that he had to upload some evidence by a certain time. He wasn't actually able to do it. And in the end, they just closed his claim. But because of Section 17.1 of the Social Security Act of 1998, because you know I like to read this stuff, guys, you know I love to do this, it clearly states there, as the judge has clearly outlined to DWP, that once universal credit is awarded, entitlement exists in law, and law always supersedes DWP guidance, thank God. So what that means, not just for this case, but for lots of you, is that your universal credit claim can then not just be closed. And I know lots of you have been threatened with claim closure for not providing evidence, because that cannot happen. Just because you haven't provided evidence, just because you didn't verify something, and just because you did not respond in time. Now, suspension is completely different, but claim closure should not be happening in the way that it is happening, and the Upper Tribunal have clearly, very, very clearly, because we can see here, he has not minced his words, that he has very, very clearly pointed this out. And for a judge to actually call out DWP and say that the way they have used closed, as in closing this claim, is total legal nonsense. I mean, I would have loved to have been in the courtroom seeing DWP's face, I'm not going to lie. But anyway, what's very apparent here is the judge, and this is why I'm always talking to you guys about evidence, he is not criticising the outcome. It's not the claim closure in itself. It's the reasoning behind it. It's what DWP, the reason that they've given to close the claim. That is what has been legally incorrect here. DWP listed these regulations, and they list them, I've seen this a lot, so it's obviously like a recycled email. Section 45, 37 and 38 of the Universal Credit Act and the Social Security Act. But then he left them in like they left it hanging in the air. They didn't actually use the right parts of those acts to qualify their reasoning. In fact, they just quoted them and then just sort of thought, oh, well, we can just quote it and then that will be that. But that's not good enough. That's not enough. And it's this type of behaviour that makes a lot of their actions, as we can see, unlawful, completely unlawful, legally not allowed. And this part as well, this is awful. The judge has said that other tribunals may sometimes need to be wary about taking at face value the Department for Work and Pensions written submission in response to a claimant's appeal. This is from an upper tribunal. So basically he's saying you can't just believe what they've said just because they've said it. Because just being the Department of Work and Pensions does not mean that you're right. That's basically what he's saying. You are not right. It's the law that is right. God, I love this judge. I love him so much right now. Now, I know lots of you are going to be going, but Ali, how can this help me? Don't worry, because there's going to be so many letters being added to that data toolkit and also the membership as well. But I am going to tell you guys this, and this is where DWP, in a sense, ignore parts of the law because I think it kind of suits them. Well, unfortunately not for this claimant and for you guys as well. So let's help you out with a few points. Regulation 38 of the acts that they have quoted do allow them to seek evidence. Does not say bank statements there, does it? It doesn't specifically say bank statements. It does say evidence, but stay with me, stay with me. Regulation 45 can allow them to suspend payment pending clarification. And by the way, that suspension cannot be open-ended. It can't be the never never land of no return, right? Decisions have to be made, particularly for vulnerable and disabled people. Now, Regulation 45, which is what they're spouting off to you all, only allows for suspension of payment. It does not provide a legal basis to end entitlement. Very, very, very important. And I've been saying it for a while. Now you're going to believe me, guys. Now a judge has said it, you're going to believe me, aren't you? Now, what DWP cannot do, and I know they love to do this, even their own legal team like to do this, they cannot treat inference as fact. So they can't just assume something, make an assumption and say, oh, that's what happened. That's the facts, if it's just an assumption. So if they say, oh, you've had a change of capital and they've got no evidence to back that up, that is trying to, pull some kind of something out of the air and say it's a fact. If there's nothing to back it up, there's no evidence, then that is an inference. They can't treat suspicion as proof. So if you want to reduct what you're spending your money on, they cannot use that as a suspicion as you trying to cover up proof. Income, what you've got coming in and your capital and any transfers, you're going to have to show that, obviously. But, if you want to cover up your Sainsbury's shop, for example, yeah, you can do that. Absolutely. I've been saying this for a long time. By saying to you, oh, if you're covering that all up, that means, that you're covering something up, that, you're trying to hide something. No, they can't do that. And they most definitely cannot end entitlement without identifying and applying the correct legal route by saying you haven't provided your bank statements. Therefore, you know, that's it. You've got capital that you're hiding just because you have not provided like unreducted bank statements. That's not going to work either. So know this and know it well. Failure to provide evidence in and of itself cannot lawfully end entitlement. And we have this Upper Tribunal decision now. Okay, so there we are. So why did DWP lose this case? Well, obviously, this is not legal advice, but this is what I think. Number one, like everything DWP seem to do when it gets to court, most of the time, they've applied the wrong legal test, if you want, to the outcome. So in a sense, that's quite bad because they've decided they wanted to close this person's claim. And then they've just pulled these things out of the air and said, oh yeah, it's this, it's that regulation. And actually, it's not those regulations at all, which is what the judge has said. Now, they need to be very careful because just wanting to close somebody's claim because you have challenged their authority in the way that they have done so is another legal discourse they probably do not want to go down, especially with the thousands and thousands of people that I hope this video reaches who are on universal credit and have had their claim closure threatened in the way that many of them have done. Now, I want to be clear here. There are certain rules and there are certain processes and things like that where they can lawfully, you know, close your claim, but not in this example, and not because you just haven't, in this particular case, because I know everybody's worried about the bank statements, not because you just don't want to give them your full unreducted bank statements. No, they can't just go ahead and close your claim. And this is another reason why I have those letters. And this is another reason why I tell you to send the letters. Because let's just say this happens to you and it goes to court and you can put in front of a judge or a tribunal the fact that you have requested what is a specific reason that they want these bank statements. They have to tell you legally the specific reason. They can't say we're just doing a random claim review. They can't do that. Okay? Well, they can do their claim reviews, but they can't force the threat of closure or suspension because you have not, you don't want to give them unredacted bank statements. Now here, I want to be very clear about this. Suspension should not be used as a mechanism to quietly erase entitlement. So it shouldn't be used as a lever against a universal credit claimant or any other type of claimant. So once a claim is suspended, the DWP must eventually do one of these three things. And I will say for a claim to be suspended, because I have been involved in doing that as well, but it wasn't for anything like this. It's for people that, you know, did not turn up ever, that didn't provide critical information that they knew they had to provide, particularly self-employed customers. So it's nothing to do with anything like this, guys. And then thirdly, payment resumes. So payment needs to be resumed and may even be backdated from the time it has been suspended. So those are the three things that they must do eventually. They must lift the suspension. Once evidence is provided, you've provided the evidence, and that evidence, as I said, can be unreducted bank statements as long as you're not covering up capital, income and transfers, and or you have given an explanation and that has been accepted. And again, if it comes down to data minimization, i.e. you do not want to be showing all of your everyday expenses because you don't have to provide transactional data according to data protection and the GDPR Act, then that is an explanation and it should really be accepted. And what this tribunal decision actually means is that non-evidence does not equal non-entitlement. This is really, really important. Now, it doesn't mean that DWP can't ask for evidence because they can do, but they must do it within the remits of the law. And that doesn't necessarily mean their guidance. And I'm going to finish up here by saying this. If entitlement is going to be changed, the legal route must be identified, justified, and applied correctly. So that means they can't say we just want to look at every single piece of your information and decide whether or not there's been a change of circumstances, whether or not there's been a change of income. Okay, that is not allowed. And it seems that from a lot of what you have been sending me, that is what they have relied upon. Well, now you have the decision there from the tribunal that says not supplying evidence does not mean that they can just close your claim. What they must do, as the tribunal, the Upper Tribunal have stated, is that they must clearly identify what change of circumstance they say has occurred. And then they should be requesting the evidence, not the other way around. They should explain why it affects your entitlement. And they should rely on the correct legal power, which really should be Section 9 or 10 of the Social Security Act, not the stuff that they've been spouting. And by the way, that's the Upper Tribunal that said that, but I have been saying that for the last few months, guys, anyway. And they should apply it to evidence, not assumption. Assumption, or assuming that just because you do not want to provide your evidence that, you know, you have something to hide or there has been a change that you don't want to convey, is not allowed. That's not legal, as the court said, and that's not allowed. So there we are. I hope that's helped you all out. I hope that brings you all joy. And all I can say is thank God for justice. Thank God. Have a great day, everybody. Take care. And leave your comments down below. I'm going to have fun reading them.